again Supreme Court said, we will not recognize foreign divorce decree, we will determine the number. This is regarding marriages, divorces and abductions. Then came liberalization of law. Justice Tirth Singh Thakur, in a brilliantly authored judgment, came out ultimately with the concept of the power of the High Court to decide and the power of the family court to decide. In that judgment authored by him, he said only if a minor ordinarily resides within the jurisdiction of the family court will the court decide. Because Section 9 of the Guardian and Wards Act says, if you reside here, only then the court can take office. But he said no. Over and above that, the High Court or the Supreme Court, exercising parents' jurisdiction in a constitutional perspective, can take cognizance, can take a decision on whether to retain the matter or whether to send the child back, whether to do a short inquiry or whether to do a long inquiry. And take a call. It was a very well-written judgment. And it has stood the test of time. There have been subsequent judgments now, with the Supreme Court getting more and more conscious on determining the child's best interests. There have been a series of progressive judgments bringing out new concepts. Justice Sikri came out with the concept of parental alienation syndrome in a matter where he said if the child stays too long with one parent, the child may suffer alienation and may start disliking the other parent. So, this concept again came out of a Supreme Court judgment. It is not mentioned in any law, it is not mentioned in any statute. We have not amended the laws, we have not changed the laws. So, what is happening? Supreme Court under Article 141, as you know, lays down the law. Supreme Court under 142 goes beyond statute law to do complete justice. So, in sum and substance, our Supreme Court is sometimes doing the job that a family court ought to do. And the High Court too, in a writ jurisdiction, is doing things which a family court ought to do. It is not the fault of the family court judge. The statute bounds and restricts the powers of the family court for custody matters, for guardianship matters. But then how do we reconcile with a world in which 35 million Indian lives? Our migratory population is more than double of most European countries which don't have even 12 to 13 million people. So what is happening? There is a clash of jurisdictions. Like marriages dissolved abroad and being divorced abroad, one will break down. We have custody orders of breakdown which we don't follow. India will respect the foreign court order only in one consideration, but will determine the child's best interest and welfare on its own. Now, a foreign court wants to know why the order of the foreign court can't be simply implemented and the child be brought back to India. There has also been a concept of mirror orders. Mirror orders means an order is made by a court, it is implemented in another jurisdiction, which is the mirror of the order. But how does it happen? It happens, let us say, India passes an order of returning a child. I did it in a matter in the plaintiff's case in Delhi High Court. Germany, we are passing an order for the return of the woman and the two children back to the US. But you go back to the court in Connecticut and ask them to give all the protections which we are offering to the women and children once they go back. So in effect, the Delhi High Court asked me to go and get a mirror order from the US, by which the US court will change its order of giving the father sole custody. And then he said that we will let the children go. Now, in the US, parental child removal is a criminal offense. It's a federal offense. US is full of states, every state has a different law. But in matters of child custody, under the Uniform Custody Judicial Enforcement Act, you can be sent to jail, you can be imprisoned, you can be handcuffed because you have removed the child. So to tone down all these things, you get a mirror order. Now, India, of its own, in its civil laws, has no mirror order provision. I don't know how many of you have studied CPC as yet. When you study the Code of Civil Procedure, which is meant to determine all procedures of civil litigation, there is a provision in section 13 when foreign judgments not conclusive. So it lays down the grounds on which foreign judgment will be conclusive. So if a judgment is on a law not recognized by India, it's an ex parte decision, it is against the principles of natural justice. There are 5 grounds. It is not recognized. So we have a no mirror order jurisprudence. We do the fact-finding and determination all over again. So therefore, we again stand out. So what has happened today? Inter-country, inter-parental child removal has become a very complex problem. And dimensions of all this are resulting in a situation where parents sometimes take the extreme steps of removing children illegally from the borders of India. It has happened, I don't know how many of you read about it, of a Russian lady who removed her daughter from Delhi, even though the passport was in the court, Supreme Court, and fled to Russia via Nepal. It is not the first time it has happened. There was another gentleman who was an Indian-born citizen, but he became a US national. He also used the Nepal route and fled India. There have also been instances where children have been removed from foreign countries and brought to India. There has been a case in Mumbai where a man went in a private jet with his own armed force, picked up a child from the Netherlands and brought the child to India. When the mother came to seek its enforcement, India said he has committed no wrong. The Red Corner noticed the extradition warrant is no good because he has not committed an offence in Indian soil. I recently did a matter in Bombay High Court where I got a child out in 7 weeks. Dutch mother, Indian father, practicing lawyer, married in Netherlands, divorced in Netherlands. The father brought the child to India. Didn't go back within the prescribed period. Refused to give access to the mother. She filed a writ of habeas corpus in Bombay. The mother came, we sat, we argued. Interim custody was to be handed over to the mother. In the evening, the father vanished again. He fled with the child and he was caught. And he was arrested by the police in Daman. Brought back, court decided the matter, and the child was sent back. The question is, why do we have to resort to all these extreme measures? The problem concerning a family and a child hits not only the family but the extended family. To an extent that the whole family, lives, business, working, mental peace is disrupted. There is a reported matter of Honor Lohiya in which I represented the gentleman, where there was strong difference between the father and the mother of the custody. There was a guardianship petition. Mother was not getting access. Father could have access. So he removed the child, fled to Dubai, took a Dominican Republican citizenship, converted to Muslim religion. The court was not at all happy about it. The Delhi High Court took it very strongly, issued contempt, variable warrants. Supreme Court intervened, CBI team went and brought him back from Dubai. Meanwhile, the family court, acting on his petition, transposed the mother, that is his wife, to become the petitioner and give her the custody. I handled that challenge in Supreme Court. And Justice Khanwilkar, sitting in Justice Brigade and Justice Murari, authored a judgment saying there is a statutory procedure on how a family court can decide on custody. Family court is not a constitutional court. There has to be a petition, there has to be a response, there have to be issues, there has to be evidence, and then procedure. So my practice in this area for 40 years, with 10 books, every book is focused on this. Now I have presented to you a worthy Vice Chancellor, a book called Remove Child in the Law in India, which is a collection of all the material on this subject. It's a very, very growing field professionally, but we again have a problem on how it is interpreted, how it is argued, and how it is handled. Now, as you get into work, you will see that in our country, everybody practices law, and everybody practices all branches of law. So you don't have specialists, you don't have practitioners doing particular areas of work. We do not even have dedicated benches for different kinds of work. In England, we have a family court bench, a family division in the High Court of London. In Australia, the family court is a totally separate structure. You have a family court structure with the Chief Justice of the Family Court of Australia. And family courts all over Australia under that Chief Justice. So you have specialist lawyers, specialist judges, and of course then you come with very fine views. Where does law grow? Law grows not in the Supreme Court. Law grows in the District Court. What the District Court or the Family Court decides, the High Court affirms, the Supreme Court reverses. So what is actually done? The judgment of the first court is the creator of law. I remember going through lectures in the Judicial Academy in Mumbai. The lecture always was, to the judges at the grassroots level, take a call. Right or wrong, take a call, decide. And sometimes to get to a balanced view, you need two extreme views. I'll give you an example. A two-judge bench of the Supreme Court headed by Justice Pardiwala says, get rid of all the dogs, stray dogs, liquidate. Wild hue and cry from activists. There is a contravening two-judge bench earlier. So a three-judge bench is going to sit today and decide what to do with the dogs. This is judicial interpretation. This is the wisdom of the Supreme Court. Likewise, in cases of marriages, there were different benches giving different views on whether irretrievable breakdown of marriage should be made a ground for divorce, and can Article 142 of the Constitution be used to resolve marriages by breakdown? It is not a ground for divorce, because Hindu marriage is a sacrament. It's a foreign-based theory. Abroad, marriage is a contract. It is lawfully asking. So you import a foreign court decree resolving a marriage, Hindu marriage and breakdown, it's not valid. But then Supreme Court does it under 142. 142 is the ultimate power of the Supreme Court to do anything to secure the ends of justice. So if the Tamil Nadu governor is going sitting on 10 bills and refusing to sign them, how long will the government wait? So the government went to Supreme Court, and again Justice Patiwala using 142 said, these are deemed to have been passed. So this is the power of the Supreme Court under 142. Now what I am trying to tell you is, we have a very vibrant, very dynamic, and a very open-minded judicial thought process, and we keep changing with times. Parental child removal is one such concept, which is totally modeled, shaped, structured on a case-to-case basis by the Supreme Court ultimately to secure the best interest of the child. On another note, we have signed in India the United Nations Convention on the Rights of the Child in 1992. It talks about the child's right to a nationality, child's right to a home, child's right to citizenship, and the child's right to live as a family. But it took us 30 years to make it a part of law. We came out with the amended version of the Juvenile Justice, Care and Protection of Children Act 2015, where we incorporated the provisions of the UNCRC to give implementation. And we have defined the best interests of the child in that law. We implemented this law in Justice General Committee's report to say, we will determine the welfare, we will return the child back. We will not return the child because there are exceptional situations. So we have created a concept. I was invited to Washington to speak for India on child relocation. Now in the West, they have gone so far. They have already thought of how to work out relocation when parents have split, remarried, but the child needs both parents. Now we haven't gone that far, but still, it was the 50th anniversary of the Hague Declaration, meaning the 1980 Convention. I am a fellow of the International Academy of Family Lawyers and the secretary of the International Child Relocation Committee. So I gave my inputs, and we said we have a very vibrant judiciary. We don't have a law, but we have the Supreme Court and the High Court working on the best interest. In a larger frame and a larger perspective, we hold the law. So as students, I would strongly urge to you is to read as many Supreme Court judgments as much as you can digest and understand as often as possible. Please go down to the judgment, not a catchy head note or an extracted report or a comment on Google. It will help you develop your thinking process. It will help you understand how courts evolve law and how concepts like the one I've talked to you about, unguided by a statutory law, are shaped by the court, that is the Supreme Court. Supreme Court is a code of record, meaning it is not bound by what it says. Subsequent bench may differ, it will go to a larger bench, as you see now in so many cases. The question of a presidential reference is before a large bench. They are going to decide whether this power, because the President of India has raised 13 questions, they have to be answered. So this vibrancy of interpretation, changing from time to time, helps evolving law. And there is no other country in the world as big as good as our Supreme Court to do this. In most countries, the topmost court is the Constitutional Court, meaning they don't deal with these issues. But our court, in the wisdom of the Constitution, has a vibrant